Will y'all be taking care of Henderson County first, or do you want to handle Mr. Curtin?
No. Henderson County and Miss Sherwood are meeting with Miss Beasley in a breakout room right now. So that's occurring right now. So that'll be a few minutes for them to go over their paperwork. So we can go ahead and call anyone else we have ready.
Afternoon, Judge.
Good afternoon. Who are you ready on?
Well, we have Ricky Norris is here. I guess start with Mr. Norris.
All right, Mr. Norris, if you'll step up, please, sir. CR 21181.
Judge, Mr. Norris has a state jail PCS case. However, it's my understanding that the state will be reviewing I believe it's sexual assault of a child case possibly this week for indictment. So we would like to go ahead and pass this case. We determine what's going to happen with the more.
Do you have any
serious assault charge.
Do you have any contested pretrial motions in this one?
No, Your Honor.
All right, there being no contested pretrial motions, the court will set this for docket call. And I'm just going to go ahead and set it out about 30 days, September 16th. Set you earlier for September 16th on another case. Is that right?
I believe we hope to do Ms. Templeton on that day. Yes.
No, I think we set Miss Templeton on the 28th.
We did, and then possibly if we get papers done before then, maybe the 16th, but 28th.
All right. Well, let's just go ahead and set Mr. Norris on the 28th as well, in case we don't. That way you'll be here the same date. So September 28th for docket call. Did you get your notice, Mr. Norris? You're excused. All right, do we have Joseph Couch?
We did, Your Honor. Hey, As the court may recall, the last time Mr. Couch's case was called in court, he tested positive, was obviously brought back to jail. Maybe a week or so or a few days later, I came over. He actually has executed plea papers for 6 years, probated for 3. However, apparently they either got stuck in the wrong file or have fallen out of the file and maybe still in the file cabinet. But he has executed those because we did it here at the jail. But I'm going to ask the court if it would consider a PR bond pending the next earliest setting we could have to enter that plea. He has executed the papers. I just don't physically have them here. Apparently, they're probably at the office.
Ms. Heisel.
Judge, I was just going to say, let me go check with Miss Abney, because sometimes when we reset them, I bring the paperwork back to her for her to prepare a judgment with the corrected date. So let me make sure we don't have those available, and perhaps we can just get Mr. Couch handled today. If not, we'll reset him.
Okay.
Okay.
Well,
That's
I would,
fine.
yeah, I'd prefer to get him resolved today.
Then I'll,
Go ahead. You can go ahead and have a seat, Mr. Couch, and when Ms. Heisel has an opportunity to check with her office, and we'll bring you back up.
thank you, Judge.
Your Honor, that's all we have right now.
All right, we'll stand in recess until we get number 3.
Thank you.
State, can you tell me while we wait, what will be the terms of the plea agreement on Miss Brittany Sherwood? I'm going to take that down.
Hey, are y'all working on getting Dylan Schroeder up here?
Yes, Judge, if you give me just a moment.
Can we bring-
Judge, the terms are upon a plea of guilty, punishment assessed at 2 years state jail, probated for 2 years, fine of $1,500, $500 attorney's fees, $20 reimbursement, court costs of $290. I don't see any 1245s or anything else.
All right, so two pro two, 1,500 fine, 500 attorney, $20 reimbursement. Is that, I guess that's gonna be total reimbursement of 520 and then court costs of 290. No reductions, no 1244As or anything of that nature.
Does not appear to be, no, sir.
All right, excellent. Thank you. Appreciate that.
Your Honor, can you hear me, sir?
Yes, ma'am, just a moment.
Okay, when you're ready, Mr. Hunt is ready with Mr. Atkins. Hey, Dakota, this is Aaron up front. When y'all had a chance, could you bring Raquel on visitation up to the courtroom, please? Thank you, sir. We are not needing cops personnel.
Right. Something to do with his wife or something. Yeah. He told me I didn't know they married. Yeah. From a hayride. Right. He's still hung up on it.
Unless he's changed our status, we are not muted, just so y'all know.
Oh. Oh. They're looking at everything we say. Oh, well. Hey, that ain't something really true.
Derek King's sister's favorite.
He was.
She was trying to get back and come do something. I was just one calling.
We shouldn't be mad at you about that. You ought to be mad at her about that.
She married her. I didn't.
She said, no. Well, he's a sometimes I come over like 5 and
All right, this is cause number CR 2237, CR 2146, State versus Chad Edward Atkins. And let's see, we are set on, is it a motion to recuse today?
That's correct, Your Honor.
Go ahead, Mr. Hunt.
Your Honor, I filed a motion to recuse back on July 13th of this year, based on information I received from a attorney who had previously represented Mr. Atkins. He said that during his representation in the previous case, that when you were DA, that you had actually made an offer in the case, which would thereby mean that you had contact in that prosecution, which would cause the necessity of you being recused as the sitting judge in this case. And so that's what we're asking, Your Honor.
All right, and State, have you looked into that matter? Has Mr. Hunt provided you any type of affidavit or anything to support that?
Your Honor, I have reviewed the record in both of Mr. Atkins' current open cases and his previous prosecution back in 2015. Your name does appear in the 2015 case in our system. However, it is my understanding of the rules that you are only recused if you have prior knowledge of these particular cases pending prosecution, which I indicted both of them subsequent to your leaving office as district attorney. I don't believe that you have any conflict with the particular cases on trial now. So state respectfully disagrees with Mr. Hunt's motion, and I assume we will need to have a hearing before the administrative judge on this issue.
And Your Honor, I can quote the Code of Criminal Procedure, Title 1, Chapter 30, Article 30.01 says that a reason or a cause for or grounds for recusal or disqualification of the sitting judge exists if, number one, the judge has previously served as counsel for the state in a prosecution of this defendant, not this prosecution.
Okay. I will need to contact my regional judge, and he will either appoint himself or another judge to conduct a hearing on the motion to recuse. Do you have any case law or anything that would support or interpret that provision of the Code of Criminal Procedure to give me any understanding of whether it should be a voluntary or involuntary? So your position, Mr. Hunt, is that if Mr. Atkins continued to commit crimes throughout his life, I would never be able to preside over any of those cases because I once in the past have represented the state against him.
Well, yes, Your Honor, just the plain language. Number one under Article 30.01 says the judge has previously served as counsel for the state in a prosecution of the defendant. Number two is the judge was personally involved in said prosecution. In other words, in this prosecution. So it does address specifically this prosecution in one section. In another section, it says any prosecution. A prosecution means any prosecution, just plain language, Your Honor. So I think just the statute is under its plain language says that you that grounds for recusal and disqualification of the sitting judge exist.
Yeah, I've spent quite a bit of time reviewing the case law that interprets that section. I wanted to know if you've done the same.
I have not, Your Honor. It's
okay. That's fine.
Seems pretty. I have not looked at the case law, but it seems fairly plain.
Judge, if I might, I would draw everyone's attention to Gamez v. State, which is 737 Southwest 2nd, 315, and I can send Mr. Hunt this site as well. Which again, I'm just looking at an annotation. I'm not presenting this as controlling at this point, although I think it may be. The annotation says the prohibition from presiding over a case where a judge has previously been a lawyer for the state or defendant only applies when the judge has actually participated in the very case that is now before him or her. Again, that's an annotation. I'm not willing at this point, because I haven't actually read the case, to say that that is necessarily what it says, but that's an annotation. I would believe everyone would be well suited to look at that for authority. That's from 1987. So just as if everyone wants to take a look at it, I think we should have a hearing, but just to guide everyone's research, I think we've discussed that in previous similar motions before this court.
And I would certainly need to look at that.
Absolutely. I'm not saying Mr. Hunt is wrong in any way, shape, or form. That seems to indicate a different reading, but everyone should do their research and we can reconvene on that later.
Okay, so what I'm going to do is I'm going to set it on the status on the motion to recuse. We'll set it for September 16th. And I will send notification to my regional judge that I am not voluntarily recusing in this case based on the stated grounds. Now, Mr. Hunt, you're not saying that I made an offer in the present cases. You're saying that I made an offer in a previous case that's not at bar.
That's correct. I believe it was a 2015 case, Judge. Correct.
Okay. So I'm not going to voluntarily recuse. So I will have the regional judge make an assignment and to hear that motion to recuse prior to the 16th. And then on the 16th, we'll discuss whether or not the ruling of the judge appointed to preside at that motion to recuse hearing.
And what was that date? I'm sorry again, Judge.
September 16th. Mm-hmm. right, so we're adjourned in Mr. Atkins' case, and we will come back on the 16th to find out the ruling by the appointed judge.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you.
Mr. Schroeder, would you step up, please?
All right, who do we have now?
Your Honor, this is Dylan Schroeder for Mr. Furlier.
All right, Mr. Murlater, this is your client Dylan Andrew Schroeder, CR 2310, CR 2137, CR 2138, CR 21242. And I believe that you have set Mr. Schroeder on today's docket on a motion to withdraw as counsel. Go ahead.
Thank you, Your Honor. I'm present in my office in Tyler, and I see Mr. Schroeder is present at the jail, and we consent to doing this by Zoom. Judge, before I continue, you said that the bail jumping cause number is CR 21-242. The last cause number that you read?
Yes, yes, sir.
Okay, all right. I just didn't have that indictment or cause number yet. For all these cases, Judge, I just wanted to put on the record first that I am not filing these motions to disparage my client or to worsen his position in front of the court or the state. I am not going to call him as a witness for any of these statements that I've made in my motion as to why I should withdraw. And I don't want to invite him to make any statements about the nature or allegations of any of his cases. Certainly, if he has any complaints about my representation, he can put that on the record. But I don't wish to call him as a witness, and I don't want to worsen his position in front of the court or the state. Judge, as I state in my motion, I feel at this point, because of the last case that you quoted, the bail jumping case, because that is indicted, I feel as though I'm a witness in that case. I've been in communication with the state about this. I provided them text messages as to why the complaining witness wanted to dismiss all the cases, saying that she was lying in all the cases. And the state, even if they dismiss all of the aggravated assault cases and the assault family violence, they could still proceed in the bail jumping case. And I made concerted efforts to bring Mr. Schroeder to court, multiple calls, text messages, and he just failed to show up on April 13th, that court date. And I was present in court. The judge, you were there, present, Judge. The state was present, and I put on the record why I believe he's not present. So I don't think I can adequately represent him because of the fact that the bail jumping charge is there. Now, if the state had dismissed that charge, then the three final cases exist. For the three cases that exist right now, without the bail jumping charge, I feel as though Mr. Schroeder is simply not listening to any of my advice. I've invited him to come to my office, to come to the court, to review the discovery, to talk about what our options are, what our strategy might be. And we're now at the point of docket call. There's been really no negotiation as far as the plea is concerned. The state and the defense are really far apart as far as plea negotiations. And I don't want to set my client up for failure if he were to proceed on any of these cases. So I'm not trying to tell the state to dismiss the bail jumping case to keep me on. That's certainly their prerogative to take anything to the grand jury that they feel is merits an indictment. But even with that case dismissed, I feel as though Mr. Schroeder is just simply not listening to my advice, and he seems to be getting advice from third parties and is trying to counter my advice. and my reading of the law and explaining to him what might happen if he does go to trial on these particular cases. So for those reasons, Judge, I'm asking the court to permit me to withdraw. I wanted to also put on the record, Judge, that, I don't take lightly of the fact that, these are 4 cases that the court, if it grants my motion to withdraw, is going to have to give to another appointed attorney. And the court already knows the caseload they have. I will say that, we have had no contested motions in this case. There's not going to be any motions to suppress, in my opinion, for any of the charges. Given a new attorney, Ms. Heisel might be willing to negotiate a different plea. And the current plea that Mr. Schroeder had rejected is 10 years TDCJ plus a $3,500 fine.
All right, well, let's take a couple of things. Let's break it down. So if Mr. Schroeder were to receive new counsel, it's certainly his prerogative, to use your word, to accept counsel's advice or reject it. Agree?
That's correct.
So it's certainly his prerogative to engage in a meaningful attorney-client relationship. Agree?
Yes.
So I can't control Mr. Schroeder to that regard. It's my job to ensure that under the 6th Amendment, that if he's deemed indigent, that he receives appointed counsel, and the court has complied with the law and has appointed counsel to him. Now, so the issue of communication or rejection of advice or unwillingness to listen, that's certainly something that Mr. Schroeder can undertake as he wishes, even to his own detriment. However, the issue of the bail jumping, I want to spend a little bit more time on. Is there some evidence that you provided to the state that the state was able to produce an investigation upon that turned into a grand jury indictment, or is it the mere fact that you were in court when it occurred?
To answer your first question, Judge, I provided the court the state text messages showing that Christina Van Diver, and I attached that as an exhibit to my motion to withdraw, and the state might use that as an exhibit in the bail jumping case if they wish to. And if I would be the sponsoring witness for this, because I was the one who communicated with Mr. Schroeder through text messages. So that's number one. And number two, as far as the state having additional grounds, well, I'll just put it this way, Judge. I wouldn't be able to craft an argument to defend Mr. Schroeder's conduct as to why he failed to appear on April 13th. That would be a defense in that case. I've put in my motion that I won't be able to lie to the tribunal because I know the truth of that case. So even if Mr. Schroeder pleads not guilty, and again, I'm not telling Mr. Schroeder to say anything about that case right now, even if he pleads not guilty, I'm not sure how I'm going to craft any kind of an argument knowing the truth of that specific case. So there's additional things that I did not include in this motion that I believe are still attorney-client privilege, and I don't want to disparage the situation any further. So if the court wants to speak about this in chambers off the record, I could certainly inform the court, but I wouldn't be able to put it on the record, Judge.
I understand. State, do you want to be heard on this matter?
Your Honor, the only thing that I would say is that should we proceed to trial in the bail jumping, state would intend to introduce those text messages, and this proper sponsoring witness for that would be Mr. Mirror Leader.
Well, while it might not be completely within the parameters of judicial economy, the solution that I see is to grant your motion to withdraw as counsel solely on the bail jumping case and to leave you on the aggravated assault with a deadly weapon cases. Do you have any objection to that, Mr. Murley?
Well, Judge, if there was a way for me to stay on while doing that, I would stay that way. But it feels that I would be put into a kind of a contentious and confrontational relationship with him on a bail jumping case where I might be a witness. So even if he is absolved of all these cases for aggravated assault and assault with previous conviction, it seems as though I would be a witness against him in the bail jumping case, creating a conflict with him and me that would probably destroy the attorney-client relationship at that point. I just don't want it to get it to that point. And I don't want to keep, asking the court for a different attorney for him. I just want Mr. Schroeder to have one attorney that he can deal with for all the cases. And it seems at this point, because of the history of all these cases and how I'm involved, it would probably be best to have one attorney for all of his cases that he can communicate with, that I could at least explain to them that, I'll provide any information that I can about our cases that I've done in my investigation, so that they could start off with wherever they would with all the current cases that are on docket call right now.
Okay, all right. The court's going to take it under advisement. I'll issue a ruling after today's docket. Not today, but it'll be after today's docket.
Just one final question to the state. You're designating the assault cases, right? Not the bail jumping cases for the trial?
Well, it's my understanding none of them have been set for trial yet, but so we haven't made a designation one way or the other, but likely we would prioritize the bail jumping for trial if we were called to designate at this point.
Okay. And if there was no agreement between the state and council as to which case would be tried, then the court would pick one.
Okay.
Okay. All right, Schroeder, you're excused.
Thank you, Your Honor.
Do we already have another setting in this case, Mr. Murleader?
No other setting, Judge.
All right, I'll tell you what, then let's make sure that we go ahead and set it at this time. Let's set it for docket call, and let's set it for a status on the motion to withdraw. We'll set it on September 16th. Do you have any conflicts that day, Mr. Murleader?
No, Your Honor.
And can you again, I think I heard you say that the offer was 10 years TDC with a $3,500 fine on the aggravated assault and the assault of a family household member. Is that correct?
That's correct. So the three cases, the state was going to ask for 10 years TDCJ concurrently, and then they were going to 1245, the misdemeanor case. I think that was criminal mischief.
So it's 10 years concurrent on each one of the assault cases, and then a 1245 of the misdemeanor. And does that offer still remain in light of the bail jumping?
Yes, Your Honor.
Okay. Okay. All right. Then we'll come back on the 16th, and I'll have issued a ruling before that time. So, Mr. Schroeder, it's very likely that you could have a new attorney before you come back. So on the 16th, we'll know one way or the other whether or not Mr. Murleader remains your attorney.
Yes, sir.
Judge, that's all I have. May I be excused?
Yes, sir. Appreciate you. All right, we're going to call Miss Beasley in the Henderson County Jail. We're going to call their case next, Mr. Manning. Just because I've got the Henderson County Jail, I got their Zoom locked up. right, Ms. Beasley, we're just waiting for the jail to move your client back to the main session.
Yes, sir.
It's my experience that they're typically out of the room, so they have to be summoned.
Judge, just to let you know, she is not currently under quarantine. So I don't know where that information came. They were told at one point they were under quarantine, but they're not under quarantine.
Okay.
Miss Beasley,
Yes, ma'am.
I'll do my best to let our staff know that, but I don't know if that's a recent development, but I'll let them know about your client today.
Okay. Do you know or could find out whether or not she's going to be released from Henderson County or if she's going to have to be transferred back to Van Sant County before she's released?
I do not know, but I will ask.
Thank you.
She's just waiting on the jail staff, so.
I appreciate you adding her to the docket today, Judge.
Oh, you're welcome. All right, Mr. Manning, if you're ready, if you want to go ahead and step up, we'll go ahead and take your client, and then whenever Ms. Beasley's client gets back in, then we'll move on to her. All right, is this Mr. Raquel?
Yeah, Judge.
All right, this is cause number CR 2189 and CR 2190. State versus Cannon, Nash, Raquel. We're set for, we're going to enter a plea today.
Yes, Judge, we also have case transferred up this morning, 2020-00596.
Right, and what's the charge in 596?
Assault causing bodily injury, family violence.
Is he going to be pleading in all three cases?
He is, Judge.
And what are the terms?
In both the misdemeanors, or sorry, in the DWI, it's gonna be a lesser included Class B, DWI first, 18 months deferred probation, $100 fine, and reimbursement amount of $85, $60 restitution. In the assault family violence, it's going to be 18 months probation as well, a fine of $100, and $15 reimbursement. I would note to the court that it appears that there were 3 court costs assessed in this case. However, I believe it's proper for only 2 to be assessed, since 2 of the cases are the same transaction and occurrence.
Are the attorney fees not calculated in the reimbursement?
Judge, those are listed on the felony.
Okay, so I thought you said $85 reimbursement on the DWI and $15 on the injury.
That's correct, Judge. It doesn't say what the $85 are for the DWI, and it doesn't say what the $15 are for the assault. There is a $6 restitution for the DWI.
Okay, where are the attorney fees represented?
The attorney fees are represented in CR 2190.
For $85?
No, Judge, for $900.
Okay, I'm sorry, I must have missed that. So I thought you said $85 reimbursement on the DWI and $15 reimbursement on the injury. Did I just not hear that right?
That's correct. There's two reimbursements, but I'm unsure where they come from, as well as there's court costs on all three cases as opposed to
Yes.
the two that should be.
Okay, so $900. Okay, so typically the reimbursement includes all reimbursements, attorney fees, rearrest fees, things of that nature. So is the 900 on the DWI with child, that's for attorney fees only? Is that what you're saying?
The injury to a child in CR 2190 has reimbursement fees of $970 total. That's where the attorney's fees are, as well as the 70 additional dollars for reimbursement.
I'm sorry, I'm so confused. Where did the $15 reimbursement go?
That's on 2020-00596, assault causing bodily injury. And then in 21-00089, there is $85 reimbursement in that case.
So all attorney fees, all three cases go through case number 90, injury.
That's correct, Judge.
All right, and so the terms on 2020-596, did you read those to me?
Yes, Judge, both for that 2020-596 and 2189, 18 months deferred probation, as well as the $100 mandatory fine for each of those causes.
Okay. And those are is that the same plea terms for the injury?
The plea term to injury is 3 years deferred.
Okay, that's,
$3,000.
so, okay, let me go back. So that's where I'm off. That's where I'm off. I thought you were reading me the felony terms, and that's why I'm confused. Okay, so now read me the terms for the injury. 3 deferred instead of 8.
3 deferred,
Okay,
$3,000 fine, $290 court cost, and $970 reimbursement.
okay. And what are the court, and so what are the court costs on the DWI CR 2189?
$270.
And the court costs on the assault bodily injury?
$270.
But you're saying that you think that's an error. You're saying that there should only be 2 court costs instead of 3. Is that what you said?
That's correct, because the DWI and the injury to a child arose on the same transaction or occurrence. Then under my understanding of what the law is, he's only to be charged for one of those two cases, and then he can be charged for the misdemeanor court costs on the assault because it was a different transaction or occurrence.
Are they multi-counts in one indictment, or are they
No,
separate indictments?
Separate indictments.
Okay, so I think that the law makes a distinction between multi-count indictments. I think you're correct. If it's a multi-count indictment, if there's 5 counts, 1 indictment, there's 1 court cost. But if there's 5 separate indictments, my understanding of the law is that there's 5 separate court costs. Do you have any case law
I don't have any case law at the moment, Judge, but I can, if the court would like, I can provide that to the court. It's standard practice based on my practice in other counties that they only provide 1 court cost for same transaction occurrence, whether that's felony or misdemeanor.
Okay, well, we're going to go ahead and assess court costs, and then if you can give me something that tells me that I'm incorrect, then we'll cross that bridge.
Yes, Judge.
Mr. Rackow, raise your right hand. I'm going to place you under oath. Mr. Rackow, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Rackow, is your name Cannon Nash Rackow?
Yes, Judge.
How old are you, sir?
19.
Mr. Rackow, are you a United States citizen?
Yes, Judge.
Do you read, write, and speak English?
Yes, Judge.
Have you ever been diagnosed with any type of mental condition?
No, Judge.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Pleased with his representation of you?
Yes, Judge.
Do you feel like you've had enough time to discuss all of your cases with him your questions answered?
Okay.
Yes, Judge.
And is there anything about the plea paperwork that you've read and signed today that you do not understand?
No, Judge.
Mr. Manning, do you believe Mr. Rackow to be competent today?
Yes.
And you've explained to him his legal rights and the advantages and disadvantages of a deferred adjudication plea?
I have, Judge.
All right, Mr. Rackow, on cause number CR 21, you are charged by indictment with a state jail felony offense of driving while intoxicated with a child passenger under 15 years of age. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years. Go ahead, Mr. Manning. Oh, that's going to be reduced to a Class B. Is that right?
That's correct, Judge.
You've been charged with a state jail felony, but under the plea agreement would be reduced to that of a Class B misdemeanor, which carries a range of punishment of not more than 6 months confinement in the Van Zandt County Jail and a fine not to exceed $2,000. Do you understand that?
Yes, Judge.
And cause number CR 2190, you're charged by indictment with a third-degree felony offense of injury to a child, elderly, or disabled individual with bodily injury. A third-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC, that is the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, Judge.
And finally, in cause number 20-2596, you're charged by information with the Class A misdemeanor offense of assault, bodily injury, causing family violence that carries a range of punishment of not more than 365 days in the county jail and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, Judge.
What that means for you, Mr. Rackow, is if this court approves the plea agreements that you've reached with the state, if the court approves those and places you on community supervision, if during that community supervision term you violate one of those conditions and you're brought back before the court and it's proven to me, then the court could adjudicate your guilt. That means find you guilty of one or multiple or all of these offenses, and the court could assess your punishment within that range of punishment we just discussed, anywhere from the minimum all the way up to the maximum. Do you understand that?
Yes, Judge.
Do you have any questions?
No, Judge.
All right, then, Mr. Rackow, how do you plead to driving while intoxicated with a child passenger under the age of 15?
Judge, he'll be pleading to the DWI first.
It's not a 1244
No, Judge.
No, yeah.
straight
Reduction.
reduction. How do you plead to driving while intoxicated?
Guilty.
How do you plead to injury to a child, elderly, or disabled individual?
Guilty.
And how do you plead to assault causes bodily injury, family violence?
Guilty.
Mr. Rackow, are you pleading guilty to each one of those charges because you are guilty of committing each one of those crimes?
Yes.
There's some hesitancy there on your part. Are you hesitating for a reason because you don't believe that you're guilty? Or do you have a question?
I had a question.
Why don't you ask Mr. Manning your question? Quiet.
Judge, I believe we're ready to proceed.
Okay, so Mr. Rackow, are you pleading guilty to each one of those charges because you are guilty of committing those crimes?
Yes, Judge.
Has anyone threatened, forced, or pressured you to plead guilty to any of those crimes?
No, Judge.
And did you have your question answered to your satisfaction by Mr. Manning?
Yes, Judge.
All right, the court will accept the defendant's plea of guilt in each cause. Mr. Manning, any objection to states 1 and each cause respectively?
No objection, Judge.
All right, State's Exhibit 1 is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
And if you can go ahead at this time, Ms. Heisel, you or Mr. Woodwhite, give me the facts supporting the pleas.
Yes, Your Honor. These actually came out of two separate incidents. So I'll start with the assault family violence first. On September 7th of 2020, Sheriff's Office was dispatched out to a location where witnesses of Mr. Rackow's significant other, they witnessed them get into a verbal argument, and then the significant other place her foot in the doorway of the bedroom, where they both witnessed Mr. Rackow slam the door multiple times on her foot, and indicate to her that basically he hoped it hurt. And Sheriff's Office both left, or sorry, Sheriff's Office didn't make contact with either one of them till later, but the eyewitnesses on scene did corroborate what the victim's eventual story was. In the other cause, Your Honor, I don't have the date in front of me, but the DWI and the injury to a child arose out of an incident where Mr. Rackow was driving his significant other and their child in the vehicle. And Mr. Rackow had been consuming alcohol that evening. Ultimately, they were involved in a rollover wreck that injured the child's leg. The child has no significant or long-standing injury. However, the child did need to be treated subsequent to that wreck, which is where the injury charge arose out of.
Thank you. Mr. Manning, any objection to that summation?
No objection, Judge.
Anything further from the defense?
Nothing from the defense.
All right, then based on the evidence, the court will follow the plea agreement in this case. Court in CR 2189 finds that there is sufficient evidence to convict Mr. Rackow in this case and the other two cases. Court will defer a finding of guilt on the driving while intoxicated Class B misdemeanor, will place Mr. Rackow on 18 months deferred community supervision, assesses a $100 fine, orders $85 reimbursement, $60 restitution, orders him to pay $270 court costs. With regards to CR 2190, the injury case, court defers the finding of guilt, places Mr. Rackow on 3 years community supervision, orders him to pay a $3,000 fine, $290 court costs, and $970 reimbursement. And cause number 202596, assault, bodily injury, family violence, court defers the finding of guilt, places Mr. Rackow on 18 months community supervision, assesses and orders a $100 fine, $15 reimbursement, and $270 court costs. Mr. Rackow, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Once you are released from jail, well, actually, there's a community supervision officer there in the court. They'll give you more information about what you need to report, where you need to report, and what you need to do upon being released.
Any judgment would be excused?
Yes, sir.
Thank you, Judge.
All right, Ms. Sherwood, are you ready?
Yes, sir.
All right. All right, Ms. Sherwood, if you'll raise your right hand, ma'am, I'm going to place you under oath. Ma'am, do you
Yes.
swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. Is your name Brittany Dawn Sherwood?
Yes, sir.
And Ms. Sherwood, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you?
Very much. Yes, sir.
Feel like you've had enough time to review your case and discuss it with her and have all your questions answered?
Yes, sir.
Is there anything in the paperwork that you've read and signed that you do not understand?
No, sir.
Does your true and correct signature appear throughout those documents?
Yes, sir.
I see that the plea agreement in this case, in which you have been charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence, is that you're going to plead guilty to that offense in exchange for the state's recommendation that your sentence be 2 years confinement in the state jail division of TDC, with that sentence being suspended, you being placed on community supervision for a period of 2 years, a $1,500 fine, $500 attorney reimbursement, $500 attorney reimbursement, $20 reimbursement fee, and $290 in court costs. Is that your understanding of the plea agreement, Ms. Sherwood?
Yes, sir.
Yours as well, Ms. Beasley?
Yes, Your Honor.
All right, Ms. Beasley, do you believe Ms. Sherwood to be competent today?
I most definitely do, Your Honor.
And you've explained to her her legal and constitutional rights?
I have, Judge, and she wished to waive those rights to enter a plea.
All right, and she understands the requirements of her on community supervision, is that correct?
That is correct, Judge. She's gone over the probation conditions and signed those and understands them.
All right, Ms. Sherwood, the range of punishment for this offense is confinement of not less than 6 months or more than 2 years. Confinement in the state jail division of TDC and a fine not to exceed $10,000. The plea agreement that you've reached with the state legally fits within that range of punishment. So I'm going to ask you, Ms. Sherwood, how do you plead to that offense?
Guilty?
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court accepts the defendant's plea of guilt. Ms. Beasley, any objection to states one?
No, Your Honor.
All right, states one's admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state other than summation?
No, Your Honor.
All right, if you'll go ahead and give me the facts, please.
Yes, Your Honor. Ms. Sherwood was pregnant. She had agreed to give her child up at birth for adoption. When she went to the hospital to deliver the baby, at delivery, both Ms. Sherwood and the baby tested positive for amphetamines. Ms. Sherwood did follow through giving the child up for adoption. However, it did not change the fact that they had both tested positive at the time of the birth.
Thank you, Ms. Heisel. Ms. Beasley, any objection?
No, Your Honor.
All right, anything further from defense?
No, Your Honor.
Okay. All right, then based on that evidence, the court will follow the plea agreement in this case. The court finds sufficient evidence to convict Ms. Sherwood and does so of the offense of abandoning or endangering a child with criminal negligence. The court assesses her punishment at 2 years confinement in the state jail division of TDC, suspends that sentence, places her on community supervision for a period of 2 years, assesses a $1,500 fine, $520 reimbursements, and $290 court costs. Ms. Sherwood, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you go with the, I'm going to have the deputies there in Henderson County fingerprint you. So ask them and tell them you need to be fingerprinted. You have all the paperwork there with you. Is that correct?
Yes, sir. Yes, sir.
All right. If you will, I don't know if is jail staff there where they can hear me at all?
No, sir.
Okay. If you'll just do me a favor and tell them that you need to be fingerprinted on that second page.
Yes, sir.
We would just kindly ask them to email or fax all of the paperwork and
Yes, sir.
to mail us your fingerprint.
Okay. Yes, sir. Yes, sir.
All right. All right. So, and once you get out of custody, you need to report to the Community Supervision and Corrections Department here in Canton. You understand?
Yes. Yes, sir.
All right. So,
Judges-
go ahead.
Sorry, Judges, if I may, I asked Erin to check while she was at the jail to see if Ms. Sherwood would have to be transferred back to Van Zandt County before she is released, and I was told that she would.
Okay. Okay. Thank you.
Mhm.
All right. Then we'll be adjourned in this matter.
Thank you.
Judge. May I be excused?
Yes. Thank you, Ms. Beasley.
Thank you.
Thank you.
You're welcome. All right, Deputy, please Who else do we have available? I do have Ms. Payne available in the waiting room as well.
Yes, Your Honor, it's my understanding that her client is actually not here though. So y'all can handle her whenever the court sees fit. I do have Mr. Knoll ready with the plea as well as Mr. Sanders here ready as well. So.
Judge, my understanding is Mr. Grace is still in the Tarrant County Jail.
Okay. All right, Mr. Knoll, go ahead and step up. All right, Mr. Knoll, who do you have with you?
Your Honor, this is Mr. Couch, Joseph Couch.
Oh, yes, Mr. Couch. Okay. All right, we are back on CR 2153. Do we have any luck in getting the paperwork for Mr. Knoll and Mr. Couch?
Judge, we do have, did paperwork completed, filled in the probation information sheet, and he reviewed the probation, so we're ready to go.
Okay, can you tell me the terms of the plea? And I appreciate Ms. Abney getting that done.
Judge, it's 6 years to be probated for 3 years, a fine of $2,500, $290 in court costs, and reimbursement fees of $785.
No 1245s or resolution of other cases?
I don't believe there's any in this case, no, Your Honor.
So this is just straight tampering. There's not a companion drug case or anything that has restitution?
No, there's not.
Okay. All right, Mr. Couch, if you'll raise your right hand, sir. Mr. Couch, do you swear that the testimony you give to the court today be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Joseph Brian Couch, is that correct?
Yes, sir.
Mr. Couch, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him, have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And does your true and correct signature appear throughout those documents?
Yes, sir.
Mr. Knoll, do you believe Mr. Couch to be competent today?
I do, Your Honor.
Does he appear to be suffering from any of the residual effects of narcotics or illegal substance use?
No, Your Honor.
And have you explained to Mr. Couch his legal and constitutional rights?
I have, Your Honor.
And do you believe that he understands the conditions of community supervision?
I believe that he does. Additionally, in this case, I believe this was an either or offer. There was actually a term as opposed to term in TDC. I think that was actually the minimum sentence of 2 years. Mr. Couch has decided, however, to take the 6 years probated.
All right, so Mr. Couch, you're indicted with a third-degree felony offense of tampering or fabricating with physical evidence with intent to impair its availability for trial. That is, under the laws of Texas, has a range of punishment of not less than 2 years or more than 10 years and a fine not to exceed $10,000. And I see here that the plea agreement today fits within that range of punishment. Your sentence under your plea agreement would be 6 years in TDC. That would be suspended and you'd be placed on community supervision for 3 years. Do you understand the range of punishment in the plea agreement?
Yes, sir.
And do you understand that your agreement today is that if you violate your community supervision and you're revoked, that your sentence will be 6 years in prison?
Correct. Yes, sir.
All right, Mr. Couch, understanding the range of punishment in the plea agreement, how do you plead to that offense?
Guilty, sir.
You pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Knoll, any objection to states one stipulation of evidence?
No, Your Honor.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. State, give me a summary of the facts.
Yes, Judge. On the date in question, is that me? No, okay. Canton Police Department pulls over the defendant for failing to yield to the ramp on the service road on I-20, and defendant pulls into the Interstate Motel parking lot. Defendant appears nervous, confirms his nervousness by telling them that when he saw them at the gas station, he knew they were going to stop him. He states something about an argument with a girl. They ask for consent to search. He denies consent. They call a dog. But while walking around the car, they see drug paraphernalia in plain view, perform a probable cause search. While searching the vehicle, they find a number of baggies floating in a 12-ounce Dr. Pepper can. The officer can see a crystal-like substance still in the bag that's not yet fully dissolved. They field test the soda inside and test positive for meth. They then dump out the soda can. That's the tampering, as he placed it in the Coke can.
Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right. Based on the evidence presented, the court finds that there's sufficient evidence to convict Mr. Couch. The court does convict him of tampering with physical evidence. The court assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence and place Mr. Couch on community supervision for 3 years. Court orders him to pay a $2,500 fine, $290 court cost, and $785 reimbursements. Mr. Couch, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted. After that, you'll speak with the probation officers to get more information about the next step. We'll be adjourned in this matter.
I think that's all I have, man.
A busy day for you, Mr. Knoll.
Thank you.
Appreciate your help. All right, Ms. Payne, I'm ready for you now. Ms. Payne, can you hear me?
I'm sorry, Your Honor, were you speaking with me?
No, I was talking to Ms. Payne. Ms. Payne, can you see and hear me okay? Ms. Payne, can you see and hear me? Looks like she cannot. Shows that she has full functionality.
She just sent me a direct message, Judge, saying, can you hear me? I just lost audio from Ms. Payne. So I think she's having bandwidth issues or something of that nature. She says she's going to log out and then log back in.
Okay.
Yazoo.
I removed her. All right. Do we have anyone else in the jail that's ready?
Jill, you're muted.
Yeah, I muted them when Ms. Payne came on. We ready on Norman Hansard?
Yes.
Mr. Hansard, come on up. CR 20339.
Yes, sir.
All right, we're set for docket call today. Go ahead, Mr. Sanders.
And Judge, I was going to ask if we could reset for one more docket call, even just a couple of weeks. I've been talking with the state where we've got a new offer, and part of the issue I've had, Mr. Hansard's a trustee, and it's been a little more challenging to try to meet up with him, even whenever I've requested for him to stay in.
at the jail. So if we could have a couple weeks, so I just gave him the new offer this, just a few minutes ago.
What's the new offer?
It's a 15-year TDC sentence.
What was the previous offer?
I
20.
think it had been 20 years.
Does Mr. Hanser need more time to determine whether he wants to take a 5-year less sentence or?
Yes, if we can have a little bit more time to discuss that possibility.
Your Honor, I didn't know nothing about the 20-year offer. I never heard any offer at all prior because of my last attorney. He never informed me of any offers, period.
Do we need to take away his trustee status so he stays there so you can talk to him?
I think I'm just going to go and meet with him after we get done here, and I think that should be pretty good. We can make it work if I need to meet with him again. I think the last time I met with him, it was like later in the day after he had gotten back from the work he'd been out doing. So
When did you get on the case, Mr. Sanders?
I think it may have been, I was appointed in into May, maybe. That's about right.
Sounds about right about May.
We'll be going on 9 months from arraignment. He was indicted and we had arraignment in January. I've got a concern if I reset it again, we'll go 9 months. Is it imperative that you have this time, Mr. Sanders, or is it a situation where I can recall him back in 30 minutes and he had made that decision?
Judge, I think it might be better if we could have a couple of weeks. It doesn't have to be a full 30 days. If there's a date the last week of August, we could do that. Especially after he indicated to me he hadn't been made aware of the initial of the previous offer.
Yeah, we're full the rest of this month. Next available date is going to be September 16th. So that's well over 30 days. That's all I've got. So be your final hearing, Mr. Hanson, September 16th. You're either going to take a plea or I'm going to put you on a trial docket and there will be no more pleas.
All right. Thank you, Judge.
Thank you, Your Honor.
You're welcome.
Your Honor, we have Richard Schmidt is here and ready.
Ready on who?
Judge, I'm ready on Mr. Hand. We also have Mr. Mata here. We've signed his papers. I think we're ready to plea on him once all of the inmates are tended to.
All right, CR 2168, Joshua Ray Hand. Court has granted the substitution of Mr. Schmidt for Mr. Stevens. That we have set the bond reduction motion on August 26th. Is that correct? Okay, that's correct.
Is that correct? All right, I misunderstood you, Judge. Are you saying that my motion for reduction is set for the 26th?
Yes.
Okay, that's fine. I just wanted to make sure. We're here on the substitution. Mr. Stevens was set for a pretrial. And obviously I'm going to ask the court for an additional pretrial setting.
Okay, court will set pretrial on August 26th along with the bond reduction. And that'll be at 1:30. If he makes bail between now and then, it'll obviously be money.
You're good.
All right, Ms. Payne is back in the waiting room. Do we have anyone else in the jail that's ready?
I believe that's all according to Deputy McNeach. I was gonna grab Mr. Mata here in a minute.
Yes, if you want to go ahead and bring him in. Try to bring Ms. Payne back in.
Can you hear me now? Okay.
Yes. You're a little bit distorted. You're a little bit distorted, but we can hear you. All right, this is cause number CR 2167, State versus Matthew Dale Grace. And I've got a note here that Mr. Grace may be in the Tarrant County Jail. Have we confirmed that?
I haven't personally checked the jail docket, but I have spoken with his family, and that is where he is. You signed a PR bond a couple of weeks ago, and Tarrant County came for transport.
Judge, I'm reviewing Tarrant County right now.
Thank you. I was about to do the same.
And Your Honor, I apologize. I didn't think I had to be in court today, so.
Judge, I do show Mr. Matthew Dale Grace to be in the Tarrant County Correction Center at this time.
Do we know what charges he's being held on in Tarrant County?
Possession of a controlled substance between 1 to 4, penalty group 1. So it appears to be a 3rd-degree felony.
It's the same charge that he has in Van Zandt County, but the Tarrant County issue is a motion to revoke, or rather, I'm sorry, a motion to adjudicate, not revoke, because he was on deferred.
Okay, well, let's reset him for docket call. What was the offer in this case to Mr. Grace?
It was TDC time, 4 years. Is that right, Tyler?
That sounds about right. I don't have that particular case up. I can look, Judge, if you'd like, but that sounds about right.
All right, let's Mr. Grace then for docket call and custody status. Are you available on September 16th?
I can be, and I will be there this time. I'm sorry, Your Honor.
Okay, September 16th, and that will be at 1:30.
Yes, Your Honor.
And we'll be adjourned in Mr. Grace's case.
Thank you. And again, I apologize.
It's okay.
May I be excused?
Yes, ma'am.
Thank you.
Hang on just 1 minute. All right, are we ready? Mr. Mata,
State's ready, Your Honor.
Ready, Judge.
all right, this is cause number CR 2261, State versus Christopher Jean Mata. And are we doing a plea today?
Yes, sir.
All right, what are the terms?
Judge, Mr. Mata is going to plead guilty. He's going to be placed on deferred community supervision for a period of 2 years. Assessed a $2,500 fine, $290 in court costs, a $35 reimbursement fee, and $180 to the DPS laboratory.
You said $30 reimbursement and 180 restitution.
Correct.
All right, Mr. Mata, raise your right hand. I'm going to place you under oath. Mr. Mata, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down. Is your name Christopher Jean Mata?
Yes, sir.
Mr. Mata, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation?
Yes, sir.
Do you feel like you've had enough time to discuss the case with him, have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Does your true and correct signature appear throughout those documents?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent today?
I do, Judge.
And have you explained to him his legal rights as well as the advantages and disadvantages of a deferred adjudication plea?
Yes, sir, in detail.
All right, Mr. Mata, you're charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. Carries a range of punishment of not less than 6 months or more than 2 years confinement in TDC, State Jail Division, and a $10,000 fine. What that means for you today is if I approve this plea agreement and place you on community supervision and defer a finding of guilt, if during your community supervision, if you violate the terms and conditions and you're brought back for a hearing and it's proven to me that you violated, the court could adjudicate you. That means convict you of this offense, and the court could assess your punishment all the way up to 2 years in a state jail division of TDC. And any sentence would be served day for day. Do you understand that?
Yes, sir.
So understanding the plea agreement and understanding the range of punishment, how do you plead to that offense?
Guilty.
Are you pleading guilty of that offense because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
Sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to States 1?
No objection.
States 1 is admitted into evidence and the court takes judicial notice of the judicial confession. State, will you give me the facts to support the plea?
Yes, Your Honor. On April 18th, 2019, the Wills Point Police Department pulls the defendant over for fail to maintain a single lane on Highway 80. And when making contact with the defendant, the Wills Point Police Department can smell the odor of marijuana emanating from the vehicle. They perform a probable cause search. In doing so, they find it's the smoked portion, a remainder of a marijuana cigarette, and they also find a vape pen containing a liquid substance that they believe to be THC. When asking the defendant about it, he admits that it is THC. Lab test at 0.3 grams tetrahydrocannabinols.
Thank you, Mr. Objection, Mr. Schmidt.
No objection to the assessment.
All right, then based on the evidence presented, anything further from the defense, Mr. Schmidt?
Nothing further.
All right, then based on the evidence, the court finds that there is sufficient evidence to convict Mr. Mata. Court will defer a finding of guilt, follow the plea agreement, place Mr. Mata on community supervision for 2 years, assess a $2,500 fine, $290 court costs, $35 reimbursement fees, and $180 restitutions order for reimbursing the agency that tested the substance in this case. Mr. Mata, did you go over your conditions of community supervision?
Yes.
Do you understand what's expected of you?
Sir.
Have you been on probation before?
15 years ago, I believe. It's been a
Did
long
you,
time, sir.
did you successfully complete it or did you get revoked?
No,
You didn't successfully complete it?
no, sir.
I don't think you're going to successfully complete this one either. Just being honest with you. Can't show up to court on time. Probably not going to go get drug tested when you're supposed to. You're probably not going to show up on time to meet with the probation officer. Probably not going to show up to pay your fees. You're probably not going to show up to do your community service. Am I right? I think I'm right. I'm going to bet against you. I'm going to bet against you, Mr. Mata. How old is that little girl you had in court with you the other day?
6.
6. She could be 8 the next time you see her. Day for day. Be thinking about that. If you care about her, if you love her, I don't know. Maybe you do, maybe you don't. I don't know. Not my business. Mr. Mata, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. Go with the bailiff, get fingerprinted, go talk to the probation officer, and I'll probably see you soon. Thank you, Mr. Schmidt.
Hey, Judge, may I be excused?
Yes, sir.
Judge, do you want us to hang out and wait for Mr. St. Julian?
No, I told Ms. Tabraham just to go ahead and move that to the 28th. The 14th, she had tentatively scheduled, but I think we're probably well over 70. And I'm afraid that if we get shut down, that's going to be a lot to do on Zoom. So I just told her to move that to the 28th. So we're going to communicate that to him and we'll reset it.
Okay, sounds good. Thanks, Judge.
Thank you all. Appreciate it.
Judge, what happened with Taylor Grizzib?
Reset, Tyler,
Okay.
to the
Okay.
16th. Yeah.
Correct.
Okay.
All right. Thank you all.
Judge,
Thank you all.
thanks.
Judge, I would note that there was not a lot of rebuttal to you. I don't think you're going to make this. That's really